We've taken our recent webinar on stock compensation planning and produced 5 topical segments. This next segment on estate planning is of particular interest because of law changes that are anticipated over the next coming years that may make taxes much higher for many of us. Take a look. I hope you'll find it interesting. Thanks.
I wanted to talk a little bit about planning with RSUs. And just by way of background, I've been in the estate planning field for the past 30 years. I've been a partner at Saul Ewing Arnstein Lair for the past 13 years and authored a few books on estate planning. So what I'm going to try and do in really just the next 15 minutes is walk you through the basics of estate planning and then what you might want to do with your RSUs, or at least consider. So starting off with the basics, I just want to make sure that everybody listening has wills with either disclaimer provisions or mandatory exemption provisions. That is, to take advantage of the current exemption amount of $11.7 million. That is the amount of money that you can pass free of federal state tax. If you do it on an optional disclaimer, the surviving spouse has the option to fund an exempt trust, whereas if you set it up as a mandatory exempt trust, the executor must fund the trust. To decide which is appropriate for you, there are a number of variables. If you have any questions on that, you could feel free to just reach out to me. And above and beyond disclaimer and exemption trust planning, there are other testamentary trusts that you might want to consider, like Q-tip trust for spouses. If your spouse is not a U.S. citizen, maybe a Q-dot trust. If you have children with special needs, maybe a special needs trust. Or if you'd like to have your assets be distributed to your loved ones over time, you can do an age terminating trust. The list goes on and on. But for basics, you want to make sure that you've got disclaimer language or mandatory exemption language, and then the appropriate testamentary trust, meaning trust under your will. And that with respect to your advance directives for healthcare and that your powers of attorney, that you have the right agents. You want to make sure that you're entrusting people with your healthcare who understand what your goals are. And same with respect to a power of attorney, that you're naming agents who can handle financial transactions for you if you can't do it yourself. Some people like to name one agent, some people name 3 agents, and majority governs. So you want to look over the options when it comes to choosing your agents under your healthcare proxy and your power of attorney. By the way, that analysis applies to your wills as well, with respect to the appointment of your executors, trustees, and guardians. With respect to life insurance, you want to ask yourself, should you own your life insurance in your name, or should an irrevocable life insurance trust be the owner and beneficiary? If it's structured as the latter, you can remove the death benefit from your taxable estate. And with respect to asset protection planning, are all the assets in your name? And if there were to be liability, would you have kicked yourself and said, geez, I should have protected these assets? So we might want to think about a Delaware limited liability company or a family limited partnership that puts a wrapper around your post-tax dollars and protects it from claims of creditors, in-laws, and outlaws. When you create an estate plan, you also need to think about the titling of your assets, your 401k, your IRA, and your life insurance beneficiaries. If you're married, maybe you want your spouse as primary, but if you have minor children, your secondary beneficiary shouldn't be your children. It should be typically the trust created under your will. So the trust govern the distribution of assets because the assets can't pass to a minor. And finally, with respect to estate tax calculation, while currently the exemption is $11.7 million per spouse or $23.4 million for a married couple, it's expected under the Biden administration that we're going to see tax legislation that will reduce that exemption. Nobody knows how much, but we can speculate on based on what we're hearing, which is it might be reduced to $5 million per spouse. And there are many who believe the exemption should drop to $3.5 million per spouse. So when you run an estate tax calculation, the idea is you add up your total asset base and then subtract out the exemption if it's 11.7, if it's 5 million, if it's 3.5 million, and just look to see what your estate tax exposure is. And that'll tell you whether or not you should be considering some additional planning. So when you consider what is your total asset base and the exemption amount. So you see here the exemptions that I was referring to. You need to know that the current utilization of your lifetime exemption is a use it or lose it strategy. That is, if you don't utilize your lifetime exemption now, or a part of it, and then Congress changes the exemption amount or reduces the exemption amount to 5 million, 3.5, or a million, that's it. You've lost it and you can't get it back. And I say the clock is ticking. We don't know when Congress is going to pass a tax bill. Most people are speculating it'll be in the third quarter, perhaps the fourth quarter, and then take effect on January 1st, 2022. But we just don't know. So if you think your asset base could exceed the exemption amount, I think what you want to do is look at some options now and see whether or not it makes sense, because the rate of tax is 40%, right? So on any assets passing to someone other than spouse, the estate tax rate is 40%. So now, what about planning with restricted stock offerings? Well, the first thing you need to do is to have a sense of what is the value of the asset. And there could be an internal matrix at your firm or company that helps you determine the value. But for estate and gift tax planning purposes, there are studies and revenue rulings that guide valuation firms in terms of issuing value for gift tax purposes. And the reason in part is because there may be a discount due to the restrictions. For example, publicly traded stocks have a ready market, right? If you're in the market, you know you can get in, you can get out, you can buy, you can sell. And because there's an ease of liquidation, from a valuation point of view, if you are gifting that portfolio to someone, generally you're not getting a discount unless it's wrapped in like a family limited partnership, which is not for now. But with restricted stock, that's not the case. There may not be a market. You may not be able to liquidate. And because of that, there are discounts from a valuation point of view. And most typically that discount is a discount for lack of marketability. Now, different valuation firms will apply different discounts based on several variables. I've been seeing the discounts in the 12 to 25% range. There are cases where the discount is higher. So just so we all know what we're talking about, if you have RSOs that, let's just say, you believe have a fair market value, if you were to exercise of $1 million, then from a valuation point of view, depending upon the variables, that valuation might be suppressed to $750,000. So if you were going to gift it, you are gifting on a tax-favored basis because your gift has been reduced by the discount. Now, the discounts that the valuation firms look at are things like strike price and the life of the option, the volatility, the timing of the restrictions, and of course the restrictions in the grant. And are the ultimate shares that you would be exercising, are they publicly traded shares or are they privately held? All these variables would be considered by the valuation firm in determining what the value is. If you were thinking about maybe gifting RSOs, you want to look internally to see if there's a valuation study, or I've seen a number of instances where a number of employees wanted to do the same kind of planning, and together they hired an outside valuation firm to affix the discount. Now, okay, what are the estate planning options? The first thing that generally you want to look at is whether or not the company allows you to assign or gift. We have had instances where we did a deep dive into creating trusts that would become the owners of RSUs or RSOs that were being gifted. And when the employee reached out to the company, they put the kibosh on it and said, we don't allow it. So before you get too far, you may want to reach out and find out what the restrictions are, or are you allowed to gift interests or percentages of the RSOs or RSUs into a trust for the benefit of family. If you are able to gift and you like the idea of gifting the asset, getting it out of your estate before there's hopefully explosive growth, you're going to want to think about, well, what is the best entity to gift into? So, for example, you can gift interest outright, so long as the company allows it. You can gift your RSOs, let's say, to different family members. But with respect to trusts, generally the trust that I'm finding for married individuals to be the most flexible is the SLAT, the Spousal Lifetime Access Trust for the benefit of spouse. And if you want, you can add descendants. Now, the reason for that is that if you own interest and you gift them to, let's say, your children, or a trust for the benefit of your children, you no longer get the benefit of that asset. But if you're gifting into a SLAT, a Spousal Lifetime Access Trust for the benefit of spouse, the theory is that the asset is now in a trust in which the spouse is the beneficiary, perhaps you might be the trustee, and that you can therefore distribute income and or principal at the trustee's sole and absolute discretion to the spouse. So in theory, so long as the spouse wants to share with you, then yes, you're gifting it away, but the income and or principal of that trust can still be part of the marital asset base because we can distribute out of that trust to spouse. If you wanted to, you could add to the Spousal Lifetime Access Trust the ability also to distribute to descendants. So if you had a child going to school or wanting to buy a house, instead of having to make a gift and utilize lifetime exemption, you can gift from the trust and not further utilize any lifetime exemption. Why? Well, because when a SLAT is formed, and using my example from before where it's $1 million asset suppressed to $750,000 by virtue of the discount, the RSUs go into the SLAT. And then let's say, knock wood, as planned, the asset exploded in growth and went from $1 million pre-discount to $5 million. Well, if that happened, you now have $5 million in this SLAT, and you might want to benefit your children. So the trustee can exercise its discretion for the benefit of spouse and children and not have to utilize any more of your lifetime exemption. So it's a very efficient way to gift. Now, if you'd like to, you can also allocate for the GST exemption, the generation skipping transfer tax exemption. And if you did that, then upon spouse's demise, the assets can pass, let's say, for the benefit of children for their lifetime, where income and or principal is distributed for their health, education, maintenance, or support, as the trustee may determine in their sole and absolute discretion, and thereafter to your grandchildren. And the asset would have then skipped estate tax inclusion in your estate and in your children's estate, and now you're down to the grandchildren. So from an estate and gift tax point of view, this is a home run. The asset just keeps growing and growing, and it's free of the 40% estate tax in your estate and your children's estate. The other thing about SLATs is that the assets are protected from claims of creditors. So to protect assets from in-laws and outlaws becomes very effective, because not only is it estate tax free, but it's free from claims of creditors. So if one of your children, let's say, gets married and then gets divorced, if you had gifted to them outright, it would be subjected to an equitable distribution proceeding. But if it was gifted into a spousal lifetime access trust, it would be exempt from equitable distribution. So when you combine this notion of creditor protected and free of estate tax for generations to come, it is a very powerful trust in which spouse has access. You can swap assets in and out. Spouse has limited power to a point. So if one of your 3 children is off the reservation and you've lost contact with them, the spouse can exercise a limited power of appointment and say, okay, well, now I'm distributing the assets to 2 of my 3 children. And also there's great flexibility with respect to the income tax effect, and that is to say that you can retain the power to pay the income taxes on the trust, or you can turn that off and let the trust pay the income taxes. So great flexibility. So what's the outcome after planning? Well, you've gifted the assets at a discount, utilizing your exemption before Congress reduces it. And once these restrictions have lifted, and you're to Jay and Dan's point, to the extent there's a diversification technique, you diversify within the trust. You can invest as you deem appropriate, and of course, we're hoping for significant growth, such that the assets are growing estate tax free, while giving spouse access, then giving children access estate tax free by allocating the GST, going down to grandchildren, all creditor protected, and if you want, you can pay the income taxes, or you can turn it off so the trust pays the taxes. Okay, so I know we've got other presenters and I don't want to take up too much time, but the idea is first get your basics done, your wills, healthcare proxies, powers of attorney, life insurance, and asset protection. And then with respect to your RSOs or RSUs, think about whether or not it makes sense to gift all or a percentage of them, if you're allowed, into a spousal lifetime access trust or an intentionally defective grantor trust.